Morning, everybody. It's Mike Kennedy, Vermont Bar Council, with the honor roll and answers to the 278th Five for Friday Legal Ethics quiz. This is the second time I've done the answers by video. They appear in the standard format on the blog, vtbarcouncil.wordpress.com. I like adding the video because it gives me a chance to do a little bit more in-depth provide a bit more in-depth analysis up to each response. Not a ton. It's not like this is CLE that's going to go on for an hour, but just a little bit more than I would usually write about when I just list the answers. Okay, first, hearkening back to the introduction to last week's quiz, some of you might remember that it had to do with the problems I've noticed in the self-checkout express line at grocery store, particularly the violations I see of the duty of competent shopping, the duty to be fair to opposing shoppers, and the duty to avoid conduct prejudicial to the administration of shopping. I appreciated all the responses I got about the intro. Two stood out. The first from a lawyer who, won't identify, told me that back in law school, this lawyer used to, at one time, where the lawyer yelled at somebody for using a credit card in the cash only lane. Now that sort of dates both me and this lawyer in that we remember a time when using a credit card as opposed to cash slowed things down. But the lawyer wrote that the person doing so needed to hear from the lawyer, lest civilization go to ruin. I agree. That's why we're fighting this fight. And then the second one that stood out was from a different lawyer, who again, who I won't identify because I'm not sure people consent to being identified just because they email back with little stories about the introduction. This lawyer wrote, it's a fantastic blurb on statutory construction. I remember now in the video, if you don't recall, I had argued that the people who run the shopping center where I shop, Hannaford's and Williston, clearly their intent in the self-checkout express lane was to only allow people with a suitably small number of grocery items, not people with full carts. Here's what this lawyer wrote. I agree with you that the legislative intent is to provide those self-checkout lines for people with small orders. This is particularly true when we look at other evidence of the legislative intent, such as the very small area provided for the shopper to place the scanned items. Exactly. Great point, one that I'd forgotten. So thank you for bringing that up. Okay, with this out of the way, I will now get to the official portion of this video, which is the answers and honor roll to the to last Friday's quiz. First, let me share my screen and we will begin. The honor roll. I won't read everybody. There they are. You're now forever famous on a YouTube video. I won't, like I said, I won't read everybody, but I will mention one person. Jen Kennedy, my mom, JB Kennedy Associates, not even a lawyer, and she's almost always on the honor roll. Great job, Mom. Okay, here we go. Question one. Last week's picture round was a bit too difficult. I think this week's is easier. I use this picture to address which of the 7 C's of legal ethics. I would like to thank the one member of the honor roll who expressed concern that there was a pole sticking out of my head. Nobody else has ever mentioned that. That's actually part of the window. But that was, thank you for checking in on my health. Appreciate it. So the answer is confidentiality. There's our 3 rules that address the duty of confidentiality. The first is Rule 1.6, the main rule on confidentiality that says a lawyer shall not disclose information relating to the representation of a client unless one of the exceptions has been met. Rule 1.9c makes clear that the duty of confidentiality applies as well to former clients, and Rule 1.18 makes clear that the duty of confidentiality applies to the prospective client, the client who meets with a lawyer with an eye towards retaining the lawyer, shares information in that initial meeting, but then does not eventually hire the lawyer. I think it's just bad form to be talking about our client matters. So that's why I use this picture. Take the ethics out of it. Whether or not a statement or disclosure might be an ethics violation, I just think you wouldn't want the professional that you hire to do something for you to be talking about the matter that they're doing for you. That's what I tell lawyers all the time, and I stand by that. Question 2. The rule that prohibits unreasonable fees includes an exception for, quote, any fee agreed to by the client. There are the choices: true, false, yes, but only contingent cases, true, but only if the client has been given a reasonable amount of time to seek independent legal advice. The answer is B, false. I blogged about this last week in a case from about, well, there it is, 19 years ago. The Vermont Supreme Court said the fact that a client agrees to a fee does not render it reasonable. This is actually language from my blog post. Indeed, the Vermont Supreme Court has rejected that exact argument, stating that, quote, now we're into language from the Supreme Court, lawyers, unlike some other service professionals, cannot charge unreasonable fees, even if they're able to find clients who will pay whatever a lawyer's contract demands. And the court cited to Rule 1.5A, which sets out the factors that will be assessed when looking at whether or not a fee is reasonable. But just remember, the mere fact that the client agrees standing alone does not make the fee reasonable. Question 3, pretty simple one. There's a rule that prohibits lawyers from advising or assisting clients to violate the law. A comment to Vermont's rule provides an exception for lawyers who advise clients about Vermont's regulatory scheme related to a particular product or industry. That is the cannabis, marijuana regulatory scheme, and it's comment 5 to Rule 1.2. So Rule 1.2D is the rule that prohibits lawyers from assisting or advising clients to violate the law. It draws no distinction between violations of state or federal law, and no distinction between violations of laws that are more rigorously or regularly enforced than other laws. Key thing to remember here when you're giving advice to Vermont clients about Vermont's regulatory scheme is the final sentence of comment 15, which is, in these circumstances, the lawyer shall also advise the client regarding the potential consequences of the client's conduct under related federal law and policy. Question 4, lawyer called me with an inquiry. Here's my reply. Quote, actually, there's an exception to the rule that allows you to do so in a post-judgment action to collect spousal maintenance. The exception is a great tool to increase access to legal services for those who can't otherwise afford a lawyer. What does the exception allow the caller to do in a post-judgment action to collect spousal maintenance? And that's agree to a contingent fee. So there's the rule. Generally, a contingent fee is prohibited in domestic relations matter, but they're not forbidden when 2 points at the end, small 1 and small 2. The question relates to D1.1, spousal maintenance or property division due after a final judgment is entered. So this is not uncommon where somebody's looking for back due spousal maintenance or property division well after the final divorce decree has been entered. They don't necessarily have funds to hire a lawyer to get what otherwise should be coming to them. Perhaps a contingent fee would work here, and perhaps that would give more people access to legal services. So that's why I remind lawyers often of this exception and I encourage lawyers to consider using it. Question 5, South Carolina case where a lawyer was disbarred last year. The lawyer's legal troubles continue. Recently, the disbarred lawyer was in federal court asking the court to vacate a confession of judgment in which the disbarred lawyer had admitted to stealing $4.3 million in insurance proceeds that should have gone to the estate of the disbarred lawyer's deceased housekeeper. Excuse me, the housekeeper died at the disbarred lawyer's house, allegedly after falling down the stairs. The attorney for the housekeeper's estate filed a motion in opposition to the request to vacate the confession of judgment. According to news reports, the attorney resorted to golf analogies, arguing that the request to vacate was the legal equivalent of "may I have a mulligan," and added that this disbarred lawyer and his legal team had stumbled late on the judicial first tee with a small bucket of balls and with the apparent attempt to fire shots until they finally hit the fairway. Obviously, the disbarred lawyer is not a golfer, neither are his lawyers. There are no mulligans. The motion in opposition went on to characterize the request to vacate as the disbarred lawyer acting like a spoiled child, overindulged and undisciplined. Name the disbarred lawyer. That is Alex Murdaugh. There are many documentaries related to the Murdaugh case. I've watched these two, one on Netflix and one on HBO or Max. They really drew me in. I was only vaguely aware of the case, from the headlines when after Murdaugh's wife and son were shot, followed it from there. Didn't really realize the depth of and the length of his family's misconduct and influence in the Low Country of South Carolina. If you're interested at all in the story, I recommend these two documentaries. There's also Elizabeth Kruska, who's on the honor roll, former president of the VBA, reminded me that there's a podcast out there that you might be interested in if you want to learn more about this. But this is really, I was drawn in and stunned, like I said, at the depth of evil and misconduct. So that's those are the answers for this week. Thanks for watching along. Not sure I'll have a quiz up on Friday. Other things going on this week, so I might not be blogging very much. But next time out, look forward to having you all participate, and I'll try to think up another good topic to rail upon in my introduction to the next quiz. Thanks for listening, and have a great day.